Welcome, everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. Our topic for this episode of the Voice of Corporate Governance is judge shopping. And my special guest is Stephen I. Vladeck, the Agnes Williams Sesquicentennial Professor of Federal Courts at Georgetown University Law Center. Welcome, Professor. Thanks for taking the time to speak with us today.
Thanks, Jeff. That title needs some work. I have to shop for a better title.
Professor, one of your areas of research and expertise is judge shopping. So can you describe for our listeners, many of whom are not lawyers, what is judge shopping? Where is judge shopping currently occurring in our federal court system? And why should long-term investors and the general public be concerned about judge shopping?
Sure. So I think it would be helpful to first start with the umbrella term that folks might have heard before, which is forum shopping. So our legal system, both in state courts and in federal courts, tends to give litigants at least a little bit of choice over where to file lawsuits, especially if the lawsuit has any kind of multi-state valence. The idea is that sometimes plaintiffs can pick and choose, sometimes defendants can pick and choose. And that's forum shopping, Jeff. And the idea there is that litigants are going to steer their case to whichever forum is best for them, maybe because of the composition of the bench in that place, maybe because of the jury pool, maybe because there's more favorable procedural rules or substantive law. But that is an inevitable and to some degree inherent part of any legal system that gives parties any choices. Judge shopping is a particular variation on the theme, which is the ability of some litigants in some federal courts to basically file their lawsuits in a particular courthouse or a particular town, and thereby guarantee that they have a 100% chance of having that lawsuit assigned to a particular judge who they know in advance. And so as opposed to forum shopping, where the idea is trying to sort of maximize in general the options for your client, judge shopping is the idea that we want this case before Judge Smith or Judge Jones or Judge Doe or Judge Vladeck, right? We want this judge on this case, and we are going to move heaven and earth to get it. And that's the phenomenon that usually is described by the term judge shopping.
Professor, you recently appeared on a panel hosted by the Federalist Society with Judge Edith Jones of the U.S. Court of Appeals for the Fifth Circuit. During the panel discussion, Judge Jones was very critical of your research on judge shopping. She described your views as, quote, very unsavory, unquote, and, quote, attacks on the law, unquote. Judge Jones also said, quote, the point of attacking these judges is to diminish their reputations, to suggest that the state of Texas and other attorneys general who filed in these jurisdictions are doing something improper, unquote. So, Professor, can you explain what her criticisms of you were, and what's your response to those criticisms?
Sure. Jeff, let me start with what my criticisms of judge shopping are, because I don't think I fully fleshed them out in response to your first question. So the problem with judge shopping, and this will help sort of set up my exchange with Judge Jones, the problem with judge shopping is not that judges are somehow nefarious actors, right? The problem with judge shopping is the public appearance of it. And so just to take the Texas example, so the state of Texas by itself as a plaintiff has filed to date somewhere around 100 lawsuits challenging different federal policies during the Biden administration. And Jeff, it's filed none of them in Austin, which is where the state government's located. And it's filed most of them in single or sort of small judge divisions, including Amarillo, where Judge Matthew Kaczmarek hears 100% of civil cases, in Victoria, which for a period of time had a Judge Drew Tipton who heard 100% of civil cases. And Texas, Jeff, has said that they're doing it because they want these cases before these judges. And the reason why I think that's problematic is because it gives the appearance that these cases are being filed where they're being filed, not because any judge in the country would rule for Texas, but because Texas thinks these judges in particular are more likely to rule for them. And without casting any aspersions on the judges, Jeff, that's a perception that our legal system, I think, would do well to avoid. That we don't want the appearance that cases are being brought in a particular jurisdiction because Judge X will rule in a particular way. So I've been pretty vocal about that over the last, 4 or 5 years. I've written a lot about it. I'm embarrassed to say tweeted a lot about it. And one of the things that I've been doing is tracking it rather religiously so that each time Texas was filing a new lawsuit, I would be online saying, they did this because now this lawsuit's automatically assigned to this judge or that judge. And what was striking about my exchange with Judge Jones is that she viewed all of that attention and all of that discussion as personal attacks on those judges. And I'll just say, folks can decide for themselves where the line is between a personal attack and a critique of the system. It has never been my view that these judges are bad people or bad judges or somehow not acting in the best interests of their job. But it is my view that they are, at the very least, unwilling participants in litigation that does not reflect well upon the federal judiciary as a whole. And that when you have judges who are keeping these cases, some of them have had motions to transfer that these judges have denied, they are at the very least turning a blind eye toward the appearance of manipulation of the system, not by the judges, right, but by the litigants who are shopping for them. And so, Jeff, I think the biggest point of departure between Judge Jones and me is that I think it's about the legal system looking bad, and she thinks it's just me trying to attack the judges as people, which I've tried assiduously not to do because, one, I don't think it's true, and two, even if it was, I don't think it would be productive.
Professor, last March, the federal judiciary's policy-making body, the Judicial Conference, announced that it had adopted a policy against judge shopping. So can you discuss that policy, including how it would prevent judge shopping, and what's the status of the policy and how has it been implemented to date?
Sure. So I think this was actually a really salutary development, although it helped to, I think, galvanize some of the opposition. Outside of Texas, we, Jeff, have been talking so far about the Texas example, but there have been other very visible examples of this phenomenon, including in cases with less of an ideological valence. So there's one particular federal judge, actually, it turns out coincidentally in Texas, who was adopting various procedural rules and local rules to try to attract patent litigation to his court. And so you had in 2021, Jeff, 23% of all patent litigation, of all new patent cases in the country were filed in Waco, Texas, which is the 23rd largest city in Texas. And that, I think, drew a lot of ire, right, from folks like Chief Justice John Roberts, from bipartisan members of Congress, because here it's not about Democrats and Republicans, it's about manipulating the legal system. So in his year-end report in 2021, Chief Justice John Roberts asked the Judicial Conference, which is the policy-making body of the federal judiciary, to study the problem. And what we got in March of this year was the result of that study. And what the Judicial Conference recommended was that local sort of district courts on their own change their rules so that they would require cases seeking nationwide relief or cases seeking injunctive or coercive relief against the federal government or against a state, Jeff, to have to be randomly assigned among the judges in that district. So basically require courts to rewrite their rules so that you can't have the same amount of judge shopping. As for the stats, so the Judicial Conference in this case didn't have the power to require courts to do anything, right? Congress has delegated to each of the 94 federal district courts. Every state has one. Some states have as many as four. But to each of the 94 district courts, the power to set their own case assignment rules. And every district court has. I think the purpose of what the Judicial Conference did was to try to nudge the district courts to change the rules on their own. And Jeff, some of them have. So there are, 6 or 7 district courts out there that changed their rules in direct response to the Judicial Conference. There are a few others that had already changed their rules. There are some individual judges who have changed their rules. The outlier, Jeff, is the Northern District of Texas. And so the Northern District of Texas, which covers a massive amount of real estate, everything from Dallas and Fort Worth to the Panhandle and Amarillo, the Northern District has quite vociferously not adopted this guidance, and it has preserved its existing single judge divisions in Amarillo and in Wichita Falls. But Jeff, it's increasingly an outlier. And so it would probably take a statute to really get rid of judge shopping on a nationwide basis. But I do think that the Judicial Conference's policy shift in March got a lot of attention and put a lot of pressure on courts outside, at least, of the Northern District of Texas to change their ways, and most of them have.
So, Professor, I'm going to give you the power to fix the federal courts in the U.S. to eliminate judge shopping. Tell me how to do it.
So, I mean, I think it's worth first, Jeff, making sure we're all on the same page about what the problem is, right? So the problem is that we don't want our legal system looking like it can be manipulated so that the plaintiff can choose their referee, right? So that the plaintiff can sort of pick the referee who's going to have the best chance of them winning. But the flip side, Jeff, right, is that we do want relatively local judges where possible, right? We want to try to balance those two things. And so it seems to me that the easiest way in a world in which I could get whatever I wanted, which, by the way, would include a Mets World Series title, the easiest way to do this would be for Congress to say, hey, district courts, we are going to leave it to you to come up with your local case assignment rules with one exception. Right. And the exception is that if there's a lawsuit by a party that's seeking relief that would go outside of the district, relief against the federal government, relief against the entire state, relief against a large corporation, say, that those lawsuits have to be randomly assigned among all of the active judges in that district. And so, for example, in the Northern District of Texas, there are, I believe, 11 active judges, right? It would be randomly assigned among them. So that, Jeff, the local cases could still be local, but cases that have national parties or national implications or even statewide implications would have to go on the wheel of random assignment. And I think that would go a long way toward eliminating this visual that litigants can basically handpick the judges who hear their cases. It may not, Jeff, change the results in that many cases. I mean, just to go back to the Northern District for a moment, right? 10 of the 11 active judges in the Northern District were appointed by Republican presidents. This is not a backdoor effort to try to sort of shift the ideological compositions of who's hearing these cases. But our legal system is premised on the idea that judges are randomly selected neutral arbiters of the disputes before them. And I think it would be in everyone's interest, Democrats, Republicans, Mets fans, Yankees fans, to work toward ensuring that public perception in the judiciary is not undermined by the behavior, strategically or not, right, of clever litigants. And that should be what I would focus if I were in charge for a day.
And that would also include Detroit Tiger fans?
Well, I mean, one day at a time, Jeff.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to again thank my special guest, Professor Stephen I. Vladeck, the Agnes Williams Sesquicentennial Professor of Federal Courts at Georgetown University Law Center. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's Jeff, that's CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to The Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.